Good morning friends, we have 2 points to discuss in this video. Can circular transactions be taxed under section 68? And B, is rule of Estoppel applicable in income tax proceedings? So far as first issue is concerned, we have our own Gujarat High Court wherein it has been held that transaction of sale and purchase cannot be treated as cash credit under section 68 if they are circular in nature. KFC Exports Private Limited, the Gujarat High Court has distinguished the facts of this case with that of NK Industries Limited, and it is stated that it is not a case of bogus purchase, it is a case where the assessee is only involved in the activity of issuing sales and purchases, so it is circular in nature and hence section 68 cannot be applied in this case. We have Rajkot tribunal decision as well on this point. It is somewhere in the month of May 2025. What has happened in this case is the genuineness of the purchases was doubted. Assessee during the course of the assessment proceedings though submitted all the details to substantiate his claim of genuineness of the purchases, but then he also made an alternate contention that certain percentage of the purchases may be disallowed, relying on various decisions of Gujarat High Court. His alternate contentions was accepted, an assessment order was passed, though in the order it was mentioned that the assessee has carried out the transactions which are circular in nature. Later on, assessee has filed an appeal before CIT appeal. He didn't get any relief from CIT appeal. Matter went to tribunal. During the course of the tribunal, the DR argued that the alternate contention of the assessee of taxing certain percentage or disallowing certain percentage has been accepted. When the alternate contention has been accepted, there remains no grievance, and since there is no grievance, and hence the appeal is not maintainable. So the question that came up before the tribunal is rule of Estoppel applicable to the income tax proceedings or not? Honorable Income Tax Appellate Tribunal Rajkot bench has relied on the decision of Honorable Supreme Court and held that the Honorable Supreme Court in the case of CIT versus Durga Prasad More 1971 1971 82 ITR 540 Supreme Court has held that the appellate authority is duty bound to ascertain the correct tax liability irrespective of what is conceded or admitted by the assessee before the assessing officer. And neither the principle of res judicata nor the rule of Estoppel is applicable to assessment proceedings. The Honorable Delhi High Court in the case of GC Agrawal versus CIT 1994-209 ITR 500, it was held that the appellate authorities, that is CIT Appeal and Tribunal, are empowered to examine the matter on merits even if the assessee has conceded earlier or admitted before the assessing officer to tax him at a higher rate. Therefore, we note that such estimated additions are subject to challenge. So this is what the Rajkot Tribunal notes. Therefore, we note that such estimated additions are subject to challenge and need to be supported by congent material and case law. If assessee now provides before the tribunal case law which is favoring to him or evidence that lower margin or lower additions are justified or no additions are warranted, the tribunal can accept the same. Hence, the argument advanced by learned CIT DR for the revenue are hereby rejected. Of course, then it was observed by the Rajkot Tribunal that the transactions are in true sense circular in nature. The Honorable Rajkot Tribunal followed the the coordinate bench decision of Pradeep Overseas, Ahmedabad ITAT, and of course the KFC Exports Gujarat High Court which we just referred. These two decisions were followed, and the Honorable Rajkot Tribunal in the case of Kamlesh Jain held that section 68 cannot be applicable if the transactions are circular in nature. So these are the two things I wanted to discuss in this video. Hope this judgment would be of some benefit to all of you. We'll see you with some new updates in the next video. Till then, please take care of yourself. Thank you.